Hi, I'm Greg Gimeno, attorney with Chesapeake Wills and Trusts and author of the book, How to Protect Your Home and Life Savings in Maryland. Today in this video, I'm going to reveal to you the number one mistake people make with their estate planning. The number one mistake people make with their estate planning is putting their kids' names on their accounts. What we get from people is why they do that is they want to make sure that if something happens to them, that their kids can write checks off of their accounts, they can liquidate the bank accounts, liquidate the stock accounts, so they can pay for their care or make sure that their mortgage gets paid or other necessities of life get paid for. And they also want to make sure that when they die, that their kids have the easiest access to the money. All sounds great, except there are legal consequences and legal significance to just adding someone to your bank account. Keep in mind, you're doing something more than just adding someone's name to your bank account. You are giving them an ownership interest in your stuff. Why is that a problem? Well, when you give someone ownership of your stuff, it is now subjected to the claims of the creditors of your kids. So you may put your favorite kid on your bank account. Your favorite kid doesn't tell you that they owe $100,000 to the credit card company. When the credit card company comes and sues your kid, they're going to see that your kid owns a bank account. And your kid's going to wave her hands and say, well, never mind. That's not my account. That's my mom's account. My name is just on there so that if something happens to my mom, that I can write checks off of her account. Well, legally, the credit card company now can come in and take money out of mom's account in order to satisfy the judgment against the daughter. Now, it may be things that you know or don't know about. Kids may not tell you everything about money, who they owe money to. But there may be also things that come along in life that you just can't anticipate. So even if your kids don't owe money debt to anybody, when you add them to your account, over time they could develop debts. They could get into bad business. They could get into an auto accident. Any number of things could happen which could put those kids into debt that then exposes everything in your account to the debts and the claims of your kids. Let me tell you one other thing that is a problem that I've seen with people who just put their kids' names on bank accounts. Let's say somebody has two kids, a son and a daughter. So if they put the son on the brokerage account that has $250,000 on it, and they put the daughter's name on a checking account that has $2,500. Well, guess what happens when the parent dies? One kid's going to inherit a lot of money on the brokerage account, and the other kid's going to inherit next to nothing out of the checking account. Now we have an unequal distribution of money out of the accounts because we have different people owning different things. If you want to wait and see a family fight and argue after death, give one a whole lot more money than you give the other one. I know people say, well, my kids will share the money, but we've seen too many circumstances and too many problems with families fighting after death to do that. So, what's the solution? How do we fix that? Well, the best way to go about doing it is to do proper estate planning. Proper estate planning will be through proper financial power of attorney documents. You take the financial power of attorney and you give it to the person at the bank. The bank will keep it on file, and now they know when something happens to mom or dad, that that's the person who's in charge of the account and can write checks off of the account, can access the money to pay for mom or dad's needs, to pay for their food, to pay for their clothing, their health care, their shelter, whatever it is that they need. Now we have something accurately on file that we're able to do that with. When you issue a power of attorney, you're not giving anyone an ownership interest in that account. You're allowing them to have access to it. The same thing, not just with powers of attorney, but we can do it with trust documents as well. You can create a living trust and say, upon my disability, this is the next person who's able to use the assets out of my account. Can access those accounts again to pay for anything that you need, the care that you need during your lifetime. So we can give someone access without giving them ownership. Your kid, who's your power of attorney, can owe $1 million to somebody, but their creditor cannot come after your bank account if your kid is merely the power of attorney. Then you may say, well, how do I get the money to my kids as fast as possible without them being co-owner? Well, we do beneficiary designations. Sometimes they may be beneficiary designations or POD, payable on death, TOD, transfer on death, some other way that we can avoid the court's probate process, that upon your death and upon providing the right documentation to the bank or financial institution, that money is able to be immediately released to your kids. So that's how we do proper estate planning to avoid the number one mistake that we see in estate planning. Again, I'm Greg Gimeno with Chesapeake Wills and Trust, and we'll see you next time.